wanted to see the whole presentation and it started 5 minutes early, it'll be online and be recorded. So the Entrepreneurial Law Clinic is a really great program at the University of Washington School of Law. I think we're going to hear a little bit about it. If you are an entrepreneur, you definitely want to know about it. Today we are doing part of an IP series that happens every year. We've talked about Patent 101 last week, and today it is Trademark 101 and Copyright 101. This is with Max Fawcett and Carrie Lee Enkin, and we're very happy to have them. So thanks very much. Enjoy.
I'm Carrie Lee, and I'm going to be covering the trademark portion of today's presentation. So just a disclaimer, this is all just general background legal information. It shouldn't be construed as legal advice. If you have specific questions or need specific assistance on an issue, we recommend you get an attorney to help you out on that. So here we go, trademarks. In the United States, they can be pretty much anything. Traditionally, they are words, symbols, slogans, symbols. They can be how a product looks or a tagline like the Nike Just Do It. All these things can be used as trademarks. And basically what it is identifying the source of a product or service. So it comes from a particular person or say a particular company. So that it's the whole point of a trademark, as opposed to say a copyright or a patent, isn't to say that I created this, but that it is from this source. And in the United States, traditionally, in addition to the traditional trademarks, you can have colors or symbols or sounds. We have some of the examples here are like the MGM lion. You hear that roar. It's actually a combination of multiple lions roaring put together, and they got a trademark registration for that as well. But like the Tiffany color, that teal, you need permission to use. And also like the Louboutin shoes. If you know Louboutin, the bright red bottom of the shoe with a contrast color upper of the shoe is also trademarked. And also like the Apple Store, how your store looks can also be what's called trade dress and registered as a trademark. Why do they matter? Trademarks, since they identify the source of this good, it helps you as a provider of that good or service. It helps you build up goodwill. It lets people take a shortcut, like, I recognize this brand, I liked it last time, I'm going to buy it again, instead of having to search and decide where to get it each time. So that's really where it's a consumer function, as opposed to maybe like a consumer protection function, as opposed to just protecting you as a trademark owner. It's protecting the consumer from having to search every time and being surprised by the quality or a difference in the quality each time they go. As for you, it helps you, like I said, create the demand for your product. As people expect a certain quality from you, they'll come back to you. And also prevents others from using your marks and pretending to be you in the marketplace. So that's protecting both you and the consumer. Now, trademarks, they have different strengths. Some are stronger than others. And this is sometimes called the Abercrombie spectrum, where you have at the bottom end are generic terms that you cannot get protection for. So you can't call an apple, but if it's in relation to computers, then it's going to be considered arbitrary, and you can get protection for that. So those are kind of the different ends. And then fanciful, you have made-up names. There's Haagen-Dazs for ice cream, but also Kodak for film. That's a made-up term. The Eastman, he thought Kodak was the sound. He thought that was trying to describe the sound of the film getting put into the camera. So that's how he came up with the term for his products. And then as you get to the lower ones, you can get descriptive marks, like American Airlines. Like that's very descriptive. It's an airline in the United States, so American Airlines. But over time, people began to associate with a specific company and a specific source. So it became a trademark over time. So how would you go about deciding if you can get a trademark or not? You can do a USPTO database search. So the United States Patent and Trademark Office maintains a registry of all the federal registered trademarks, and I'll go into a little bit on that, on different types of registration, but that you can go to the USPTO database to search and see what's been registered federally, and you can go on just to do a quick Google search and see if people are using that company name, even if they haven't registered it yet. And there are also state databases that maintain state registrations that you can go and search as well. So these are the different places you want to look, because since this is something for identifying a source, you don't want anything that's too confusingly similar to yours, because consumers won't be able to identify a source if they're too close together. So as I was mentioning, there are multiple types of protections. So unlike say a patent where you've probably learned last week, you have to be very secret, you have to file before you let anyone know about it. Trademarks, you can start using it, and by using a trademark in your business, you've already gathered some protection. You use it in order to be able to register it. So just using it, even with no registration, you have some rights and to prevent others from using it. Now, that's very limited. It'll be limited to where you're using it and to the extent of your market. But at least you don't need to register to at least have some rights. To get up to you can go up higher into a state law. So let's say you're not doing business in multiple states, but you're just doing business here in Washington. You can file at a state level and get state protection. And it'll protect you in the entire state, even if you're just, say, running out of Washington, running out of the city of Seattle. You can enforce it across the entire state. But then when you start doing business in multiple states, you can file at the federal level with the USPTO, and that will give you nationwide protection, even if you're only doing business in a few states. So that's the strongest protection, but it's also more expensive to file, and it's more expensive to police. And then once you have registration at the USPTO, you can use the ubiquitous R symbol. But if you haven't registered, you can use a TM or an SM symbol. SM is for service mark. So if you're doing tax preparation services, that would be an SM. But if you're providing, say, a software package, that would be under a TM, or like an article of clothing would also be a TM. And this puts people on notice. It lets them know that even though you haven't registered, you're beginning to use this as a trademark. And so they can't claim ignorance that they didn't know that you were using that portion as a trademark. Now, there's a quick note that in the EU, it's against the law to use a symbol until it's been registered. But in the United States, you can still use the TM or the R, and then the R symbol once it's registered. Now, enforcement, the important thing about trademarks is not only is this protecting you, it's protecting the consumers. So you have a duty to police your mark, because if you start letting people use your mark on other products, it begins to become confusing and not become a source identifier anymore. It becomes more diffuse. And so it's not protecting the consumer and being able to identify where something's coming from, and then you're going to lose your mark because you aren't allowing the mark to be used for its purpose of protecting the consumer. So you have to look for the unauthorized uses, and also you have to pay attention for things that might make your term generic. Like there used to be a company called Flashlight that made electric torches. People started using that as the generic term for electric torches here in the United States. And they finally lost the trademark, and they eventually went out of business. There's no flashlight company in the United States anymore. And then there's also dilution. You could do an entire course just on dilution, but this is where people start using your mark in other ways, on maybe ways that aren't confusing, but begin to dilute your brand. This is why Coca-Cola wants to go after people using it on t-shirts, not just on other drinks. That's where the dilution comes in. And like I mentioned, if you don't police your mark, you're going to lose it. And then once you find a mark that might be infringing, you go to the courts and, well, first, hopefully you can do a cease and desist letter to to the person who's infringing, you believe is infringing your mark, and hopefully they will just stop, or you can work out an agreement with them. If the both of you working out together realize there probably isn't going to be that much confusion, or you guys can come to an agreement that you're going to stay out of each other's markets so that there won't be any confusion in the future, that's also an option. But if it ends up going to the courts, they're going to have all these different factors that they're going to consider. And both the strength of your mark, how close your marks are together, and although they will look at the intent of the other party about whether they meant to infringe on your mark or not. The big issue here that they're going to look at is, will consumers be confused? Because that trademark isn't just protecting you, it's protecting the consumers. And it doesn't matter, like say, if you are accidentally infringing someone else, it doesn't matter if it was an accident. You are liable. Now, the good and bad of this is, even though there are damages, injunctions, and attorney's fees that you could be awarded, or someone could get a judgment against you, most of the time, all you're going to get is an injunction. So that's something you need to think about when you're thinking about going to litigation, is you probably aren't going to get damages from the other party, just a court order telling them to stop using your mark. So that is something from an economic perspective you're going to have to think about on how much of my market is going to be eaten up by this other use of the mark, and how risky is it am I going to lose this mark going forward, because litigation is expensive. I think we just had a presentation today that trademark litigation is roughly anywhere from $120,000 to $750,000 per litigation. So if you have a lot of people infringing your trademark, you're going to have to think about that, how you want to handle that, because taking all those people to court may eat up all your money, and as a startup, that money may be better spent somewhere else. Now, in the United States, we do have fair use, both to keep that in mind when you're trying to describe your product, and also when you're trying to analyze whether someone is infringing your mark. There are two major categories, are descriptive fair use and nominative fair use. So the descriptive fair use is, a lot of times you have the weaker marks, say, like I have my example here, Sweet Tarts. Sweet Tarts is the name of a candy. That's the trademark. I think it's owned by the Willy Wonka brand of candies. But it's also descriptive in that it's a flavor. So if I want to describe the flavor of cranberry juice as Sweet Tart, I'm not infringing on the Sweet Tart trademark. And then there's also nominative fair use. And this is where it's a bit of more of a practicality balance here. It's like, when is it so cumbersome to be able to refer to a product without using a trademark? So like I have my example here. If you had to say Seattle's professional baseball team every time you wanted to refer to the Mariners, that would be very cumbersome, but also it's really not doing any damage to their mark to say the Seattle Mariners, especially in the context. But be careful with nominative fair use. When you want to use another company's name, make sure you're only using it to the limited extent necessary. Like if you're selling it on their product on your site, you're allowed to give its name. But you don't necessarily have the right to use their logos or any of their other marks if it's not necessary for the purpose of what you're doing. And just a little bit of interesting things in the news recently with trademarks. There's the Slants. It's an Oregon-based band. Although I do believe at least a couple of the band members are from just down the road in Issaquah. And they were trying to trademark their name of the Slants, and it got denied registration because it was disparaging. It's because the Slants has been used as a pejorative term in the past. And this is the portion of the Trademark Act where it says different reasons why you can't get a particular term trademarked. Like it's immoral, deceptive, scandalous, and the key term here in this case was that it was disparaging. And so they went all the way up to the Supreme Court. First, the Federal Circuit had said this was unconstitutional, and usually whenever you get a constitutional issue, the Supreme Court will pick it up. And so they took a look at this, and just this past summer, they ruled that the disparagement clause was unconstitutional and violated the First Amendment, so freedom of speech. Now, some of those other terms that I mentioned in that act, there it said, they didn't find that they were unconstitutional, but it could be in the future. Things like immoral or scandalous may get challenged in the future, since that also seems like First Amendment right issues. But right now, only the disparaging portion was found unconstitutional. And so, I mean, this is good from a freedom of speech perspective, although some people are concerned that what does this mean for some of the other offensive marks that they will now be allowed to get registration. So like the Washington Redskins, they had finally lost their registration after many, many lawsuits. So it now looks like that it might get reinstated since this term was found to be unconstitutional. But I mean, there's a question of, well, the United States is just a registration, so should it be up to the consumers to decide what is disparaging and what are they going to support, as opposed to the government deciding what should be disparaging? So that's going to be an interesting question in the future. I'll turn it over to Max and talk about copyright.
Thank you.
Yep.
Okay. Good afternoon. All right, so I'm talking about copyright. So copyright stem from the Constitution. Just the one section just reads, to promote the progress of science and the useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. So obviously inventors is covered by patent, but for authors, we're covered by copyright. All right, so copyrights, there's original works of authorship that are fixed in a tangible medium. And the key here that we put in quotes is that copyright protects the expression, not the idea. So you can have an idea, but it has to be fixed, it has to be in paper, it has to be recorded. You have to fix it in some kind of medium in order to get protection. And then, so these are the two elements. It has to be original, and as I said, fixed in a medium. The bar for originality is insanely low. We'll talk about it in a later slide. There is a level that you have to meet, but again, it's a really, really low bar. As I mentioned, it's a really, really low bar. So there are things that don't qualify as original. So let's say you're an author and you're writing, or comic book author, and you're writing a story about a superhero who saves the city from crime. That's probably not original enough, but once you slap him in a cape, say it comes from Krypton, he shoots fire out of his eyes, that starts to become more original. You think of Superman, that's enough. So character archetypes again, so if you're writing a story, a novel, and you're just talking about the tragic hero, that's not original enough, but once you start adding more elements to it, he comes from so-and-so, he does this, he does X, it starts to become more original, and then you can get a copyright on it. So copyright can cover just a huge swath of things. It can cover literary works, as I talked about, including software, both object and source code, musical works, dramatic works, pantomimes, choreographic works, pictorial, graphic works, motion pictures, architectural sound recordings. It covers a whole gamut of things. And I love these animations. Okay, so there are things it doesn't cover. So one of the biggest things about copyright is that, as I mentioned before, it doesn't cover unfixed works. So if I'm a jazz artist and I go on stage and I just start improvising and there's no recording of it, there's no videotape of it, it's not being fixed in any way, I can't get a copyright on that because it's never fixed in any medium. Ideas, as I mentioned, and then there's an idea called the useful articles. So read this quote to you. So an article that has an intrinsic utilitarian function that is not merely to portray the appearance of an article or to convey information. It's just a fancy way of something. If something is inherently functional, you can't get a copyright on it. So the prime example is, we all know those are bike racks. We see them all over the city. The original creator of the bike rack, it had a little bit of a different design at first, but his friend came to him who rode a lot of bikes and said, you know, that design is actually perfect for storing bikes. So he tried to get a copyright on that, but whatever artistic elements that he put into making that bike rack, you can't really take them away from the functional aspect because the loops are part of holding the bikes. And so if you can't separate the artistic elements of whatever it is, you can't get a copyright on it. So, and again, a perfect example is a t-shirt. A t-shirt is inherently functional, keeps you warm, shows off your guns, yada, yada, yada. But the moment you put something on it, say a design, a t-shirt, a logo, then the logo itself is copyrightable because you can remove that from the t-shirt. And so copyrights grant you broadly 4 rights. So the right of reproduction, the right to make copies. So if I'm an artist and I create a painting, one of my rights is I can make copies of it. I can sell posters, I can sell pictures, I can put it on postcards, and that kind of stuff. So the right of adaptation, so the right to make derivative works. So again, if I'm the original copyright holder of, let's say, Star Wars, I have the right to then take my characters or the aspect of Star Wars, put more things to them, create offshoot stories. Those are derivative works. So all the new reboots now would be considered derivative works off of the original. The right of distribution, again, if I want to go out in the parking lot with my trunk open, start selling my DVDs, if I own the copyright in Star Wars, I can do that. And then the right to publicly perform. If it's a dramatic work, if it's a pantomime, if it's choreographic work, I can go out in the street or, I can go out and perform it publicly. It's important to note that these are, the term of art in the legal community is a bundle of sticks. So essentially, each of these rights is an individual right in and of itself. So let's say I create a screenplay for a movie, but I don't have the ability, obviously, to turn that into a movie. I can then license or assign some of my rights to other people. So the difference between a license and an assignment. License is saying, you, in my stead, can make use of any one of these rights, versus an assignment is I'm just giving you away the right. I no longer have the right to do any of these rights. So kind of like trademark, as Carolee mentioned, you can register your copyright. It's really straightforward. You can do it online. I think registration is around $50. So it's much, much cheaper than, say, patent or trademark registration. And it gives you some important rights. So it establishes that you have a copyright claim. So if you, in the event that you want to bring someone to court over copyright infringement, the fact that you have a federal registration per se means I have a valid copyright in my thing. They're not going to come to you and say, well, what you are claiming I'm infringing on isn't copyrightable, because the federal government has said, no, it is, and you're totally fine. Again, if you want to bring a suit for copyright infringement, you have to have a valid registration. And then again, as I mentioned, provides a legal presumption that the copyright is valid. So if you go to court, you're not going to have someone who's going to contest your claim by saying what you're claiming I infringed isn't copyrightable because the government has said that it is. All right, so ownership can be sticky. So if a work has one or more authors, it's called a joint work. And the thing with a joint work is both parties, or as many parties as there are, they have to intend for their joint aspects of the work to be joined as a whole. So there's a case where, I think it's for the movie Ali, Spike Lee hired someone to come on and advise on some of the production aspects of it, and I think he helped rewrite some of the script. So he came with a suit claiming that he had contributed to the work, so he was an author. But the point was, the other people involved in the film never intended for his part to be a part of the whole, so he wasn't a joint author. And this can also be sticky in employment circumstances if you're an independent contractor. Usually, if you're hired by a company to do something that is copyrightable, it's going to be a work for hire, and you're not going to own that. It becomes a little more sticky when you're an independent contractor, because there's a multifaceted test to determine like how much control over you and the work did the company have, how much originality did you put into it, did you use their tools versus your tools, a bunch of different things. So if you're an independent contractor and you're creating works for a company that could be considered copyrightable, you want to make sure that before you start work, you nail out and hammer out who owns what. Is it you? Is it the company? You just want to make sure you have that kind of stuff written down. Also, assignments, the difference between a license and assignment. If you're giving away your rights, that kind of stuff has to be in writing. Just in general, if you're doing any kind of thing with you're giving away your rights or you're licensing your rights, you want to get in writing. But especially if you're giving away your rights, it just needs to be in writing. Okay, so duration. Works created after January 1st, 1970. It's the life of the author plus 7 years. So it's a pretty extensive period of time that your work is protected. This differs for works created before 1970, but presumably all your works were created after, so that's not an issue right now. Anonymous works and works for hire, again, 95 years from publication or 120 years from creation, whichever is shorter. The Mickey Mouse conspiracy is interesting. So there's a theory that every time Mickey Mouse comes up to, quick note before that. So once protection ends, the work falls into the public domain, and anyone can do whatever they want with it. So the theory is every time Mickey Mouse comes up and he's about to fall into the public domain, Disney lobbies Congress, and they extend the length of protection longer and longer and longer. So as opposed to being life of the author plus 70 years, when he comes up, it might be life of the author plus 90 years, because obviously Mickey Mouse is incredibly valuable to Disney, and they don't want to let him fall into the public domain. So there's something called fair use. So if you are a copyright holder, you have to be aware that there are people can use your work, so you don't get a monopoly on your works. So fair use doctrine, there's 4 different factors to it right here. The purpose and character of the use, which has another sub-factor, was it transformative, which I'll talk about in a second. Is it for parody, criticism? So you take, you guys know who Weird Al Yankovic is, right? Okay, perfect. So he obviously does parodies of famous songs, Gangster's Paradise, I think he turned it into Amish Paradise, things like that. So he gets away with it because it's fair use. Criticism, critique, so that's like for news. Educational purposes, so teachers aren't getting sued every day when they use copyrighted works in their classrooms because it's for educational purposes. The nature of the copyrighted work, the amount you're using, so if you're using like a de minimis, if you're using a really, really small part of a copyrighted work, it's okay. And then the effect on the potential market. So if your use of a copyrighted work is affecting the original copyright holder's ability to market their work, that's going to weigh against you in court, because the court's going to feel like that is harming the original copyright holder. And the picture down here, which is about the limits of fair use, is from an exhibit called Canal Zone. So it's from this case, Caillou versus Prince. So Prince spent a decent amount of time living amongst a Rastafarian community in Jamaica. And once he got their trust, they allowed them to take photos of them. So he spent, I want to say it was like over a year. Yeah, it was like over a year living with these people, and he finally got their permission to take pictures. So he took several pictures like these and put them in kind of like a photographed coffee table book that he ended up selling. Richard Prince is an appropriation artist. So an appropriation artist is someone whose business it is to take other people's work, change them around, and then sell it as their own. So he took photos like this and then threw a guitar on there, blurred his face a little bit and added on some blue paint, and then started selling and made a huge art exhibit of photos like these that they were selling for hundreds of thousands of dollars. So Caillou brought suit against him saying, look, you're taking my hard-earned work and just changing like a few things about it and selling it as your own, and I'm not seeing any of those profits. So the first court found, yes, this is straight copyright infringement, because what Prince is doing, you could argue it's transformative because he is changing some elements of the photo, but because he wasn't making a commentary on the original work, he couldn't claim fair use. But Second Circuit reversed that, saying a work can be transformative without commentating on the past work. So just because this photo right here doesn't necessarily make a comment on this photo doesn't mean it's not transformative. There's an argument that transformative use is kind of swallowing up copyright at the moment, because, I mean, for me, I think just changing the color, shading a little bit, putting on a guitar and putting blue over his face isn't necessarily transformative enough, but the court found that is transformative enough, so he could claim fair use in doing that. Prince has made a habit of doing this. He's been in the courts a ton of times. I think the last one he did, he was taking famous people's Instagram photos, blowing them up, putting on additional hashtags, and then selling them. So he makes a habit of doing this quite a bit.
So in the case of music, if you don't mind me
Yeah.
interrupting, in the case of music, it's common, right, where people will go in and take an existing song that is copyrighted.
Like they'll sample it.
Well, the same way sampling, but just like, change the beat a little bit, or might change the progression, but it's inspired by the same song. Would that be considered transformative?
It depends. So there's, as I mentioned, there's no exact definition of what is transformative enough. So it depends. If they're taking a lot of it, it could be considered, so that's one of the factors, the amount and substantiality of the portion used. So if you're taking maybe like a drum kick of a song, that's not enough, because people aren't going to be able to recognize where it comes from originally. But if you're taking enough, I'm trying to think of a song that would be, if you took the opening of like Hotel California and put it in your song, and I could hear that and I could recognize that as coming from Hotel California, that's going to be too much. Oh yeah, so there's the Marvin Gaye, Robin Thicke controversy right now, where Blurred Lines took a significant portion of one of Marvin Gaye's songs, and they lost that suit.
Even though
Mhm.
That's, so,
It's a gray area. There's no defined this is infringement and this is not. The courts will take all these factors into account, and they'll try to just look at the song, look at the infringing work, and determine how much did you use? Is it affecting the market of the other person's work?
but
Did you?
what if they wanted to do a parody of it?
Yeah. So like Weird Al doesn't get Weird Al doesn't get sued for his stuff. Coolio tried, but he lost for Gangster's Paradise versus Amish Paradise.
Is there anything in copyright, in fair doctrine use, where the owner, and this actually might apply to me, where the owner of a particular item finds that the usage and the fair use is destructive or not consistent with the values of the brand or the copyright itself?
Mhm.
So like in the case of the Slants,
Yeah.
as an example. But let's say if Coolio did not think that doing something that is Amish Paradise was consistent with
His exact argument, actually, yeah. So he claimed that he wrote Gangster's Paradise because of his experience in the streets, and that the Amish Paradise was kind of spitting on what he was trying to convey. For music, it's different. If you are like a sculptor and you have artistic works, you have something called Vera. It's not in this presentation, but you have moral rights in your artwork. So if you do sculptures or paintings, you have moral rights in your work. So you have some limited ability to say, look, what you're doing with my work or how you're using my work is not what I intended for the work, but for music, it's a bit different. Yeah.
This whole area, I'd say, is pretty case specific.
Yeah.
There aren't any hard and fast rules in terms of what is transformative. There's tons of case law on this.
Yeah.
I'm actually a music lawyer. It's not something where you're going to get a straight answer in terms of what you're doing. Transformative helps, but again, that's not going to stop you from getting sued.
And then, so currently in the news, Taylor Swift was sued for her song "Shake It Off." I don't know how many Taylor Swift fans we have in here, but if you ever heard it, there's a line in it that goes, "Because the player's going to play, 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 play." I'm not going to sing it because I don't have that ability, but there's a song by 3LW called "The Player's Going to Play," and in that song, there's a line quite similar to this, but it's not as long. And as I mentioned before, there's some level of originality required in order to get copyright protection. Court found that these lyrics don't meet that. So I don't know if that's an indictment on pop music or Taylor Swift herself, but in general, this is not original enough to have copyright protection. So the owners of the copyright in Player's Gonna Play lost that suit because what she was doing, or this right here, isn't copyrightable in the first place. So, and that's it for copyright. Any questions?
Actually, I do have a couple more, if you don't mind.
Yeah.
So earlier you were talking about copyright, some people we can copyright.
Yeah.
In terms of a word, right? So many people, like Lucasfilms, has copyrighted so many words, droids, etc. I try to use droid and I couldn't use it.
Yeah.
Because it was very similar to the way that they wanted to use it. But if you took a word that had a very specific definition in photon,
Okay.
right? There is no currently a definition that describes it as a planet or something else. So going back to the comic book thing, right? So if you create a definition of a word that isn't commonplace, but it is for a particular story or narrative
Yeah.
that you're creating for your particular business, can we create a copyright on that word that is already in the definition but defined as something completely different that is not related to how it's defined in commonplace?
So correct me if I'm wrong. I don't know if you'd be able to get a copyright for the word itself, but the story that involves the word, yeah. So take Harry Potter, for example. There's words in there that mean, like Dumbledore is made up for that story. So in the context of Harry Potter, it's copywritten for Harry Potter.
Right, so the word, if it's a made-up word, sure, understood. So,
Hmm.
so
But
what
you want to
word-
change it, so like
Just the
phaser or
definition.
photon, yeah. So it'd have a completely different meaning in your world that you're creating.
Yeah, absolutely.
Yeah, I think that would be okay. In the work itself, yeah, that should be fine.
So the definition, so when we apply for copyright, we have to be very specific about how we define that word.
Yeah, or like in this story,
Yeah,
in this
story narrative.
Space Odyssey, it means this. It would be different than the regular meaning, then yeah.
Okay.
Yeah. Any other questions? Oh, yeah. Join me.
Yeah, question about copyrights. When Microsoft bought the company that owned Minecraft game? And the answer to this question might be, I think you need to talk to a lawyer. It's okay. But anyway, when Microsoft bought that company that owned the Minecraft game for $2.5 billion, it came, I found out that the guy who was the principal stockholder and also originated the game had been, he had another company that owned the copyrights to the game and had licensed them to the company that was doing the Minecraft stuff. So my question is, how prevalent is that where somebody like this guy had this idea for this computer game and cranked out code and got people to play the game, and other people wrote code that went into the game, but he was the one that was basically making a lot of money, like 8 figures, on licensing the rights to his ideas and everything to this company, and then Microsoft bought that company. So how does that work?
In terms of him being the only one who's profiting off of it?
Yeah.
Okay. Again, correct me if I'm wrong. I guess that, again, it goes to ownership. So if you're an employee for a company and you're writing code, it's his idea for Minecraft, but you're the one writing the code. Presumably, if you're an employee in your employment agreement, it'll say, look, the things that you're doing are owned by the company. So the individual coders who are writing the source code, they don't have any claim to the code. So yeah, it's not uncommon for these companies to have the copyright and license it out. That's how a lot of these people make a lot of money. That's why a lot of the publishing houses who own the copyrights in a ton of music make all their money because they license out the ability to perform it or to publicly perform.
I mean, generally copyrights sit with the author.
Yeah.
But an exception to that is work made for hire. So if you're an employee of a company and it's in the scope of your job and you're creating intellectual property, that will sit with the company. You can also hire somebody if you're a company and have them sign an agreement that says that what they're coming up with is work made for hire. So I think if that's the question, the answer was correct.
And it's also pretty common, and it's also pretty common for companies to set up a separate entity to hold their IP. You know, whether that's right for you in your situation, I mean, that's when you go talk to an attorney, but it is pretty common for a company to make a separate entity to hold the ownership to the IP. And sometimes there's some benefits possibly for, like, if the operating company goes bankrupt, there might be some advantages there.
Excellent. Hello. So this is actually a question that kind of transcends both copyrights and trademarks. I think that there's a situation here that I'm maybe having to deal with. I'll first go with the copyright and trademark situation. Photo Robot is both a company and potentially a character, right? So Photo Robot, FOTO-robot, is currently trademarked by a company in Europe. And we do two completely different things. I do have prior use in America, though. However, in thinking about copyrights, can I create a character called Photo Robot, copyright the character, although there might be a company that has Photo Robot trademarked? Is there a law or anything that says trademark prevails over copyrights or copyrights prevails over trademark? And they're two completely different things.
Yeah.
Not in the United States. In Europe, they are more strict about, once you've registered a trademark, about having more exclusive use over it, like even in what we would consider fair use situations here. So, I mean, you'd have to go look and see on the European trademark law about that. But in the US, it probably wouldn't be a problem if you're completely separate products and markets.
It's also the difference in the regimes. So as Carolee mentioned, trademarks are for source identifiers, and if you're creating a character that's not being used to sell a product or identify your service or your good, then you should be okay.
Okay, and just a follow-up question specifically to that for trademark specifically. I apologize, I walked in a couple slides late, so I'm going to talk about it.
We start early.
The prior use, that's one thing I'm kind of curious, because I have a prior use situation with a particular trademark that I do want to trademark. And although Photo Robot was trademarked in Europe some time ago in a completely different class than what I'm going to register in, my use, when they registered, filed for registration in the States, mine was several years prior to hand. I understand that there is potentially some opportunity for me having prior use of the mark to register as a trademark Could you elaborate a little bit more on prior use in trademark
Yeah.
world?
So the U.S. is an outlier in the rest of the world. The rest of the world is first to file. But in the United States, it comes from, for the federal registration, you must use it. So if they haven't used it in the U.S. yet, and you have been using it in the U.S., then you claim priority. So it's first in time in use, as opposed to first in time to file.
Okay,
So
that's-
you do have priority in the United States. I think you'd be out of luck in most other countries in the world, though.
Oh, yeah, all that matters is for the United States. And
Yeah.
why is it that, how is it that people can get away with filing a trademark in a wide variety of classes, even in ones where they don't even apply, locking other people out potentially?
I guess if they've applied and they claim they're intending to use there, they can kind of reserve it. In other cases, it could be those other classes are so similar that a consumer could believe that a company could go into that space. So
if you
that,
sell T-shirts, it's more likely than not you're going to start selling hats and
Yeah.
beanies and that kind of
Yeah.
stuff.
but no one's going to confuse, Delta bathroom sinks with Delta Airlines. That's why those coexist. But someone coming in to do Delta faucets or Delta kitchen, that's probably going, even though it might be in a different class, that might be getting too close because a consumer could legitimately think that Delta, as a maker of bathroom fixtures, could move into kitchen fixtures.
Okay, thank you.
Mhm.
This might be a little bit off topic, but for the example with the bike rack, so he couldn't file copyrights, but could he file for a utility patent for that design?
Yeah, he could. He could have, but he displayed it and brought it out to the public first, and so then, at that point, he had waited too long to file. But if he'd thought about that, yeah, he could have filed a patent.
Okay, thank you.
Mhm.
Anything else? Cool.
Great.
Thank you guys.
Great, thank
Thank
you.
you very much, the Entrepreneurial Law Clinic.
Thanks for having us.
Like catastrophic mic failure, but
I know.